Okay, are you guys getting that QR code to work? How many are signed in? Okay. Scan the QR code. I'm going to take it down in like a minute because Mike is going to get started. I will throw it up on the breaks. Did you guys have fun last night? Good, good. I went to Ulta and spent way too much money. You know how that happens, right? All I needed was eyeliner because I ran out. And I didn't want you guys to see my eyes unlined. You know what I mean? It was a thing. Panicked. Okay. Have my last stragglers scan the code. I will put it up again. Remember, you just need to scan it once. Okay. Danny, let me know when you got it. You got it? Okay. Oh, back row, do you guys get it? Don't worry, I'm going to put it up on the first break. You guys act like I never give it to you. Gosh. Okay, can I take it down? Going once, going twice. I don't see anyone waving at me. Okay, that should work.
Excellent.
Yes, it does. Okay. Okay, everybody, please give all your attention to Mike Roker.
Good morning, everybody. My name is Michael Rooker. I am an attorney with the Indiana State Board of Accounts. So I work, of course, with Stacy and Ricky. They're wonderful, and I work with them and talk to them, I don't know, many dozens of times every day. If you send a question to one of them, there's a pretty good chance that the three of us all talk about it, and we think about what we're going to say as thoughtfully as we can in response to you before we formulate that response. To give you a little bit of a background about me, I've been with the State Board of Accounts since November of 2023, so it's going to be 2 years here in a couple of weeks. Before that, I worked for 14 years in local government, like all of you folks. I was the city attorney for the city of Bloomington for 14 years, so this is my field. I love local government. That's what I literally did for most of my career, and now I'm doing it with all types of units, counties included. Unfortunately, I have no cute kid pictures to share with you like Stacy, so I'm not going to be buttering you up with that. But I do enjoy Marshall, so I did get to spend some time with him, so that was lovely. I wonder, do we have anybody here who's been to law school or who went to law school for a little bit or who has any experience with that? I'm going to do this presentation a little bit like a law school presentation because we're going to talk about cases or like a continuing legal education presentation that lawyers go through. So the formula for that usually when you're talking about cases is sort of to break it down. You talk about the facts of the case, so that's really what happened, here's where we are. You talk about the legal issues that are presented, so the questions that the court is trying to answer. You talk about the holdings, so what the court actually said, how they answered those questions and why, and then sort of any key takeaways that may be relevant going forward for you all when you're working as auditors. Hopefully, I won't bore everybody to death. I should also say, when you get to the point where you're litigating something, you really have gone pretty far down the path. Most of the time when we have a dispute or some sort of disagreement, that gets resolved locally without anybody filing a formal legal complaint in court and asking for a judge to issue a ruling. And then usually if it does get to the point where a legal complaint has been filed and you get a judge's ruling, that's resolved at the lowest court level, the trial court, our circuit or superior courts here in the state of Indiana. for a dispute to rise to the next level beyond that, where it gets appealed to the Court of Appeals or the Indiana Supreme Court, that's a big deal. That's a sign that we really had a serious dispute. Either there's a lot of money at issue, or alternatively, there's something that the parties just can't agree on. So all of these cases we're going to talk about are Court of Appeals cases or Indiana Supreme Court cases. So they're pretty intense cases. So we got pretty far down the path there and didn't get it resolved locally. Of course, I would encourage you to resolve things locally whenever you can. I do have to give you a couple of disclaimers. This is what I have to do as an attorney for the State Board of Accounts. I am the agency's attorney. I'm the State Board of Accounts attorney. I represent the agency for which I work. That's the State Board of Accounts. And of course, we do our best, Stacy and Ricky and I, to provide you with the best advice we can when you have questions or when you find those ambiguities that need to be resolved in your daily work. But I can't represent you as local counsel. If you want the sort of magic, binding, legal opinion that you can point to in court and say, look, I asked my lawyer and they told me to do X, I can't provide you with that, but your local counsel can. Only your local counsel can do that because I'm an attorney for the State Board of Accounts. And then, of course, I want you to know we're dealing with some intense situations. Some of these are less than 20 years old. I don't know anything about these situations that we're going to talk about in these cases independently. I haven't hired a private investigator to look into the facts. I don't know anything about them except what I get from the court's record. So if I report a fact that happened in a case and you have personal knowledge of it and you say that's not exactly right, I promise I'm not trying to lie to anybody or anything like that. I'm reading what the court reported in the official record in its order. So, all right. Let's dig into it. So, the first case we're going to talk about is State on behalf of Vanderveer versus Butcher. This is a super, super old case. It's an Indiana Supreme Court case, so that's our highest court in the state of Indiana, so it has the most precedential value from my perspective. And it's about meeting minutes. Now, this case is more than 100 years old, as I said. It's a 1933 Indiana Supreme Court case. It is the facts that gave rise to the dispute in this case are from 1925, September of 1925. So those facts are, this happened more than 100 years ago. Okay, so here are the facts. In September of 1925, the Howard County Council held a regular session. After the session, the auditor prepared minutes for the council's approval, and the minutes were prepared and entered into the record. This is the normal process, right? The auditor is the clerk of the county council and the commissioners. You prepare the minutes and they review them. Among other things, the minutes indicated that the appropriation ordinance adopted for the calendar year 1926 was not prepared prior to the regular session and was read only on one day and not on two separate days as required. That's really interesting that that's part of the minutes. That doesn't sound normal or right from anybody's perspective. And so we had somebody, and this guy has a wonderful name. His name is Ferdinand Vanderveer. He has a wonderful, very old-timey name. I have no idea what position he held, by the way, Mr. Vanderveer. I tried to look up Ferdinand Vanderveer to see if he was like a public official or something. The only thing that Google tells me is that somebody with that name was a Civil War general, but that's not this guy, so I'm not sure what his interest was in modifying the minutes, but he wanted the minutes changed to reflect that the appropriation ordinance was read on two separate days, that it was done appropriately. So he files an action in mandate. And so this is for lawyers, when an action is filed in mandate, that's sort of unique. Most of the time when you file a civil case, you're seeking damages, right? So you're trying to say, hey, this person harmed me in some way, or there was a breach of contract and somebody owes me money. And so what you're seeking is the judge to say, yes, I'm going to award you a certain dollar sum. An action in mandate is different than that. When you have an action in mandate, you're asking the court to order somebody to take a specific action, right, to do something. And if they don't do what their court ordered to do, then they'd be subject to judicial sanction. So the action that Mr. Vanderveer wants the auditor to take, Mr. Butcher in this case, is to modify the minutes, to say, hey, the appropriation ordinance was read on 2 days. And so the court sort of phrases this in a really interesting way. The court says, if an individual is seeking a court order to alter county council minutes, is it appropriate to name the county auditor as the defendant? So that's the legal question. We would say, lawyers would think of this, or at least I think of this as a question about who the defendant is or how the caption should read. Should the caption of this case be Vanderveer versus Butcher, the county auditor, or should it be Vanderveer versus the county council? So that's sort of the question that the court is trying to resolve. And we love to do this in the legal community. We say, hey, the question is about who's the defendant, right? Did you name the correct party? Do we have the proper people in court? Even though that's not really the question that the court is answering here. The actual question that the court is answering, even though it gets framed in this weird legalistic way, is ultimately who has the authority over county council minutes? If you want to order somebody in mandate to change those minutes, do you order the auditor to change those minutes, or do you order the county council to change their minutes? So what we're figuring out here is ultimately who's responsible for the county council's minutes. And we get some great old school language from this 100-year-old case. So what we get from the Indiana Supreme Court is the auditor as ex officio clerk of the council is merely the, and this is, I'm not even sure if I'm saying this right, the amanuensis of the county council. So this is some wonderful, dense legal language. Ex officio is one of those legal Latin phrases we use that means if you are the auditor, by law, you are also the clerk of the county council and the county commissioners. So it's just a legal phrase, a Latin legal phrase that means by your position, you're also responsible for this other thing. And then we get this great word, amanuensis. I had to look this up. I had no idea what this meant. And me being the huge nerd that I am, I thought it was so cool that I had to look this word up that the Indiana Supreme Court used. It means one who takes dictation or copies manuscripts. So what the Supreme Court is saying here is the auditor's role in the county council's minutes is really, really modest. If the county council says, write down A, your role really is to write down A, right? That's ultimately the position that you're in. So the Supreme Court is acknowledging that the county auditor's role is relatively modest. And then we get some other language that I find absolutely fascinating, which is, and I'll read it to you, there certainly must be some stage in the preparation of the minutes after which the ex officio clerk, that's the auditor, cannot change the record for the purpose of making it conform to what he thinks it should be. This would be true whether the change in question would have the result of making the record speak the truth or an untruth. That's really remarkable, especially that second sentence to me. The court is saying, and this is important, they're not going to be concerned with the accuracy of the minutes in this context, right? And this screams to me that Mr. Vanderveer in this case, and the record doesn't indicate this, but this is what it feels like to me. Mr. Vanderveer appears to have rock solid proof that in fact the county council heard the appropriation ordinance on multiple days, and he's gone to court and he said, look, they've got to change the minutes because they're just flat wrong. The minutes are lying. And so he sued he asked the county auditor to change the minutes, and the court is saying, look, we're not going to worry about whether the minutes are accurate or not. That's not what the auditor is supposed to do. The auditor is supposed to simply listen to what the county council wants the auditor to say in the minutes and then write that down as the person who takes dictation of those minutes. So this is really limiting the county auditor's role with regard to minutes. Now we know that the county auditor's role is more important than that, right? Your office prepares the minutes. You take a first shot at the minutes, you draft the minutes. And in my experience, more times than not, after the minutes are drafted and submitted to a body for approval, they read them over real quick and they just say, yep, let's adopt them, right? They don't make a lot of changes to the minutes in my experience in local government. And so that gives the person who is preparing the minutes a great deal of authority over those minutes. But at the end of the day, the body that owns the minutes is the body themselves. So it's the commissioners or the council who are responsible for those minutes. Now, and so what takeaways do we get? So the outcome here is very legalistic. Again, it's, hey, Mr. Vanderveer, your case is dismissed. You got to go back, you got to start again from the beginning, and you got to sue the county council if you want to have the minutes changed. You cannot name the county auditor. The council's responsible for their minutes, and so you got to go after them. You can't come after the auditor. So that the takeaway really is that the council and commissioners own their minutes. You're the ex officio clerk of those bodies and you prepare the minutes, but at the end of the day, they belong to the county council and the county commissioners. Now look, well, this is interesting, right? It may feel like it's a limiting holding on your role in terms of being the clerk of those two bodies. I think it's really actually somewhat of a relief, right? At the end of the day, if the council or the commissioners insist on putting something into their minutes that isn't accurate, or you don't feel correctly reflects the record or isn't complete, you are not going to be responsible for that. Now, that doesn't mean I think you should be cavalier in preparing the minutes, or that auditors should say, it doesn't matter what I write in there, right? It's going to be fine. I'm not responsible for it. Courts aren't going to hold me liable. You should do your best, of course, right? And of course, if you see something that you think is blatantly false that's being put into the minutes, it never hurts. Never hurts to document that, right? To write down what you think happened, to document it in a memo, to date it, and to include that in a file somewhere, so that if somebody comes back after the fact and says, look, we think that the appropriation ordinance was read on 2 days, even though the minutes that the county council approved and wrote down indicate it was only read on 1 day, that you have a record saying somewhere that you disagree with it. Now, that won't be officially in the minutes, but it will be somewhere else to protect you. So, okay. Well, we'll go from minutes, which is a very exciting case or a very exciting topic to talk about, to income taxes. So the next case is about county adjusted gross income tax and contracting. So this is CADGT. Of course, we don't have CADGT anymore. That particular portion of the tax was eliminated when local income taxes were overhauled in 2015, and we have now a lit structure. And this is a case that is far more recent than the last case that we talked about. So again, I want to emphasize, if anybody in this room knows anything about this case, I promise I am not one of those people. Everything that I'm reading is just from the record from the Court of Appeals. So this is a Court of Appeals case. It's from 2005. And the facts in this case, in June 2000, this is a Hendricks County case. The Hendricks County auditor ostensibly signed a contract with a Mr. Coonrod and his accounting firm. In executing this alleged contract, neither the county commissioners nor any other county official approved the contract. So the only people who approved the contract were Mr. Coonrod and the county auditor. It was a contingent fee contract, where Coonrod was entitled to recover 1/3 of any assets that his firm recovered for the county. So he got a kind of finder's fee if he was able to identify dollars that the county was entitled to that they weren't aware of. Well, lo and behold, Mr. Coonrod alleged that he identified $8.2 million in CADGT funds to which Hendricks County was entitled. Now, again, I don't know the specific facts of how that happened, but that would mean that Mr. Coonrod was entitled to $2.7 million. Well, Hendricks County decided that they didn't believe he had an enforceable contract. They did not pay him his $2.7 million, and so he ended up suing the county for his finder's fee. Now, I am curious, and I don't get this from the record, I'm super curious what that contract looked like. I'm wondering if it looked like a normal contract or if it was more like an engagement letter or something like that. But ultimately, the court doesn't really care about that because they make this about procedure and not the actual form or substance of the contract itself. Okay, so the legal question that the court is faced with here is the contract with Coonrod an enforceable agreement, right? Is it enforceable because it's only signed by the auditor? And they frame that in this very long particular way. In this case, we are confronted with the issue of whether a county auditor has the authority to contract with an individual for the identification and collection of various county assets and funds in exchange for payment to that individual for such services, absent permission to do so from the appropriate governing body. So really, the question, if I'm really going to boil it down, is can you guys, as county auditors, execute contracts like this on your own, independent of the county commissioners approving it? And this is a pretty significant deal, right? I mean, can the county auditor sign a contract that's going to obligate $2.7 million of county funds without the county commissioners looking at it? I'm going to guess that most people in this room know the answer to this, and they can guess what the court said. And the court said that the auditor lacked authority to enter into the contract with Coonrod and that the contract was therefore unenforceable. And we get this wonderful language again from the Court of Appeals. There is nothing indicating that the auditor, absent approval from the county, has the authority to enter into a contract to pay a fee to a third party for the recovery of assets such as CADGT funds. And again, this is kind of the expected outcome, right? This strikes me as a sensible result. That's a lot of money. You would expect that the county commissioners would look at a contract that's obligating that amount of county funds. And so it feels like this was sort of somewhat predictable, and Mr. Coonrod's case may have been a little bit of a tricky one to try to win. Okay, so the outcome is that Coonrod's case is dismissed, and he is not entitled to any compensation, so he gets no money. I'm not sure precisely what Mr. Coonrod did or what the facts are that led to this recovery by the county, but ultimately he gets no dollars as a result of it. And that's a pretty harsh result, I think, from Mr. Coonrod's perspective, right? He doesn't get a single penny, even though he thinks that he had some kind of agreement for the recovery of funds. And then, of course, from your perspective, auditors do not have independent authority in most circumstances to contractually bind a county. So that's not something you can do on your own. You've got to follow the proper legal process. And of course, this is a 2005 case, which is 20 years ago now. So since then, of course, we have now a process in code passed a couple of years ago regarding the process for contracting with a county. And that says that in almost all circumstances, it's going to be the county commissioners who have to approve a contract. Hopefully you guys are all sort of familiar with the process in 36 to 2.8 and 2.9, which talks about the county contracting policy. Auditors have a key role in that process. So hopefully that's something you've heard of. The real takeaway, I think, when I read this case, or at least what I think about when I read this case, is that it's sort of a cautionary tale more for private parties who want to contract with public entities, right? If you're an accounting firm or some other services provider and you're going to enter into a contract for payment with a county, you better darn well make sure that the county followed the process that they needed to approve that contract, or you might not get paid. Right? I mean, the result here is that Mr. Coonrod doesn't get his money. There's no real negative consequence for the county. They get their $8.2 million in Cadget funds, and they don't have to pay that finder's fee at all. So, okay. The next case is going to take us back in time again to the 1960s and 50s. This is a Vigo County case. This is a really dense, complex case. If you guys... Hopefully you never read legal opinions because that's just a miserable thing to do. But this one in particular is terribly miserable to sort through and figure out precisely what's going on. This is a case about purchasing, specifically purchasing asphalt. And this is a case that intimately involved our state agency as well, the State Board of Accounts, back in the 1960s and 50s. So I'll get into the facts here. There are a lot of facts in this case. I've tried to pick out just the portions that are relevant so we don't get too lost in the midst of everything that's happening here. So in 1958 and 1959, Vigo County purchased $65,000 in asphalt. Just to give you a sense about what that means in modern day dollars, that would be about $725,000 today, about $750,000 of asphalt. So that's a lot of money they're spending, the county is spending, Vigo County is spending. The process for purchasing the asphalt or selecting the vendor was appropriate. The purchase was competitively bid. It was awarded to the lowest responsible and responsive bidder. So the procurement side is perfect, right? We've got the best price we can get for the asphalt in Vigo County. But then a step was missed. After the procurement process was done, no contract was executed with the asphalt provider. So the county auditor could not produce a contract. The highway supervisor couldn't produce a contract. The commissioners couldn't produce a contract. The basic fact here is no contract was executed. The asphalt was provided. It was provided in the correct amounts. Claims for payment were submitted by the vendor and appropriately certified, and then the auditor sent those claims along to the commissioners. They approved them, and warrants went out, checks were issued to the asphalt vendor. Just through the normal process, all of that side of it looked good. So what we have here is a process that looks pretty close to right. We have appropriate procurement. The claims process looks good, but the missing piece here is there's no contract between the county and the asphalt provider. Well, after the fact, the State Board of Accounts comes in and does an audit of Vigo County, as we do, and we notice that there is no contract in place, that the auditor was paying claims, and there was no contract to pay claims for the asphalt that was provided. And so the State Board of Accounts is very frustrated with this, and they work with the Attorney General's office, and they actually sue the auditor, and more specifically the auditor's bond, to recover the $65,000 on behalf of the taxpayers of Vigo County. And the court frames the State Board of Accounts, the state's argument, as that the auditor was sued because the auditor was required to withhold claims where there were no legal contracts and evidence. The State Board of Accounts argued that the county auditor is required to keep a record of all contracts between the county and third parties in order to check the validity of claims presented. So the state's position was, look, the auditor has to keep a contract here, and they have to look at every claim that is presented, and they have to check it against the contract and make sure everything lines up. It's a pretty reasonable position to take. And then they really sort of did something pretty aggressive here and said, look, if you're not going to follow that process, we're going to require you to pay that back personally, or more specifically, the company that you have a public official bond with to pay back the taxpayers. The auditor responded and said, look, all of the payments that I issued to the asphalt provider, they were made in good faith. They were ordered by the county commissioners. The auditor pointed out, look, I got an opinion from the county attorney that said I didn't need a contract. In this particular case, I've got certification from the highway supervisor saying, look, when I got asphalt, it was in the amount that's consistent with the invoice. It was at the correct price. The highway supervisor signed off on it. I did everything correct with the claims process. Under those circumstances, I should not be personally liable for the repayment of this. And that's a pretty big deal. I mean, we're talking about big sums of money, $750,000 and $25. So, okay, so this sort of comes out in the form of two legal questions that the court is faced with. The first one is maybe a little bit less interesting. In determining whether a claim is correct and payable, can the county auditor rely on the assertions of third parties like the county attorney, the highway supervisor, and the county commissioners, right? Can you rely on those assertions? And then the second question is more interesting. It's whether or not the auditor can be held personally liable for claims paid when no contract supports the payment. Now, it's really important looking at the way the Court of Appeals has framed this question. The question is not, do you have to have a contract? Because I'm going to tell you, spoiler alert, you need to have a contract in place in this circumstance, right? That's required. You cannot be buying asphalt in this quantity at this sum without having some sort of contractual agreement. The question is whether or not the auditor is personally liable in the absence of a contract under this circumstance. Well, the court digs into this, and with regard to the first question, in determining whether or not a claim is payable, can you rely on the assertions of third parties? The Court of Appeals said, yes, of course you can, right? The auditor acted within the scope of his authority, relying upon the certified statements of the highway supervisor, department heads, guided by the advice of the county attorney, and following the determination of the Board of Commissioners. So the fact that third parties were looking at the claims and you were following the normal claims process means that when the auditor paid those claims, it's likely that they're going to be not personally liable. That's the result we're going to get to here. And again, sort of the takeaway when I read a statement like this from the Court of Appeals, this is sort of saying, look, the closer you are to the normal process, the better you're going to be. The more you're engaging the brain trust and getting certification from the department head, from your county attorney, following the process and putting claims in front of the commissioners, the more you're going to be in a safe space and not likely to be held personally liable. So you're always on safer ground when you work with your team and get as close to the normal process as possible. Okay, with regard to the question about whether or not the auditor can be held personally liable, the Court of Appeals says not under the facts presented in this case. And the Court of Appeals is really focused on the fact that, look, there's nothing truly untoward happening here, right? The auditor acted in a manner devoid of dishonesty, devoid of secrecy, devoid of deceit, devoid of pecuniary gain, devoid of fraud, and the municipality obtained value received for money spent, and hence the auditor should not be held liable. So, the court is focused on the fact that ultimately the county bought asphalt here. They bought it at a fair price. They bought it in the amounts that were certified in the claims. And that's going to be the critical fact, right? The auditor didn't do anything that's truly inappropriate or truly untoward. So what are the takeaways from this old, complicated case? Well, the auditor is not liable, right? Again, that doesn't mean that the auditor shouldn't have had a contract for the purchase of that asphalt. It doesn't mean that a step wasn't missed. It just means that the auditor is not going to be personally responsible for that. So again, when paying claims, an auditor may rely on the assertions of other county officials. So getting the advice of your county attorney, making sure that that claim has been signed off on by the department head, making sure that it's going in front of the commissioners and getting approved, that's all critical. And then a missing contract, probably by itself, while it may present a compliance issue, is not going to lead to personal liability on behalf of the auditor. It's not going to lead to what we call at the State Board of Accounts a chargeable action, right? We're not going to come after you or your bond in your personal capacity in that situation. Again, it's important to note what this case doesn't say. It doesn't say that an auditor can never be held personally liable or that your bond can't ever be called. It says if you're just missing a contract and everything else was buttoned up, that's probably not going to be enough for you to be held personally liable. Now, I will tell you, and Stacy and Ricky can nod or shake their heads on this, if we audit this type of payment and we don't find a contract, I would bet it's going to be a compliance issue. Now, I don't know that you're going to be held personally liable. You probably won't, but it will still be somewhat embarrassing, and there will be an arc, most likely, in that circumstance. So get your contracts. Okay. I feel really, I don't know. I feel like Tom Cruise kind of. That was great. It's my like mound music. That's wonderful. Yeah, great. I'm just like Tom Cruise. Tell my wife. So, all right. Next case is Klein versus Hughes. So we're doing sort of old and then new. This is a 1997 case. This one, I believe, involves Spencer County. And this one is in federal court. So here we have a Seventh Circuit Court of Appeals case. So in the broadest sense, there's sort of two court systems in America, right? We have our state courts, 3 levels to those, our district courts, Court of Appeals, and then Supreme Court. Same thing at the federal level. We have our a 3-tiered system. We have our federal district courts, and then our circuit courts, and then the U.S. Supreme Court. So this is the Seventh Circuit that's ruling on this case. That's our particular Court of Appeals that governs Indiana. They sit in Chicago. And why are we in federal court here, right? Normally we're in state court with questions about whether or not the auditor has certain authority. Well, we're in federal court here because it's a federal question. This is a First Amendment case. So this is a case about party affiliation and whether or not it's appropriate to terminate and hire an employee based on their political party affiliation. So it's a federal question, and that gets us into federal court. Okay, the basic facts. In 1995, Doris Hughes, a Republican, is elected as the new auditor in Spencer County. She takes office on January 1, 1996, as county auditors do. And then the outgoing auditor, a Democrat, on December 15th, 1995, just before Ms. Hughes took office, she notified one of the deputy auditors, Ms. Klein, that she would not be retained. So this is happening just before she is to take office. The outgoing auditor, of course, was a Democrat. She had not formally designated one of the office staff that as the chief deputy auditor, but of course, when Ms. Hughes looked at the record, she noticed that Ms. Klein had filled in for the auditor when the auditor was absent from council and commissioner meetings. So she looked like the first deputy auditor. The incoming auditor, and this is great, I love it when you get language like this in a legal case, but the incoming auditor said that in terminating Ms. Klein, she needed to hire somebody as a first deputy auditor who she could trust, right? And the court is pretty explicit in saying, look, when we read that language, we know that that means she feels like she needs to hire a Republican and she needs to terminate Ms. Klein because she was appointed by a Democrat. And so the legal question we get is related to the First Amendment. The question is, did incoming Auditor Hughes lawfully terminate and replace Ms. Klein, or did the termination violate Klein's First Amendment rights? Now, this is really important for local government attorneys who practice any type of employment law. Generally speaking, party affiliation, almost always, is not a permissible basis for a termination or a hiring decision. It usually is not. If you do that on the regular, you will be found to have violated the First Amendment. Somebody's going to sue you, and you will ultimately be liable to that person, right? Usually, hiring and firing decisions by the government have to be made based on competency, based on diligence, reliability, work ethic, things like that. It should not be based on party affiliation. Of course, there are some exceptions, and in this case, we get to one of those exceptions. So, the holding from the Seventh Circuit Court of Appeals is that county auditors are free to select their own chief deputy auditor, and party affiliation is a permissible basis for said selection, and termination can be based on party affiliation as well for your chief deputy auditor. And when the Seventh Circuit made this ruling, they were really focused on the importance of the chief deputy auditor role. What they said is the Office of Deputy Auditor plays a vital role in the implementation of the county auditor's policy. The power in that office is underlined by the legislature's specific authorization that the elected county auditor has the authority to appoint a first or chief deputy auditor of her choice. So there's some statutory language that says the auditor gets to select their chief deputy auditor, and so that was relevant for the Seventh Circuit. The Seventh Circuit also pointed out that the chief deputy auditor at times is going to serve as the auditor explicitly. They're going to serve in your role. A deputy county auditor is more than a clerk or an employee. He is vested with the power by express statute to perform all duties of the auditor, and public policy requires that this be so. Again, this makes sense, right? Your chief deputy auditors at times, they're going to be standing in for you. If you go to the hospital, if you have a family emergency, if you, God forbid, take a vacation, right? Your chief deputy is going to have to attend those council meetings, those commissioner meetings. And so they're essentially going to be standing in your shoes. And in that sense, the Seventh Circuit is acknowledging that we have an exception here, right? You can take party affiliation into account in this limited circumstance because the chief deputy auditor is essentially the auditor at times. Okay, so what are the takeaways here? I've kind of already said them, but county auditors have broad authority to select whomever they prefer as chief deputy auditor. And you have a lot of reasons you can do that, right? You are empowered to take, as a chief deputy auditor, you're empowered to take any action the auditor may lawfully take. Again, I'm sure you guys already know that. And what that means for you is you should select your chief deputy auditor thoughtfully, right? Be very careful in selecting that person because they are going to take actions that you are ultimately responsible for. Now again, as I said many times, and I can't emphasize this enough, this is the exception. Normally, party affiliation is not a permissible basis for a hiring or firing decision. Don't be doing that on the regular. This is one of the limited exceptions. So I would also always encourage people to be thoughtful. In this particular case, obviously the auditor felt like she really needed somebody who was a Republican to serve as the chief deputy auditor. I will tell you, in my experience in local government, far more important than party affiliation, I worked with Democrats and Republicans and people who were neither. Far more important factors in terms of getting the business of local government done were diligence, reliability, work ethic, competence, experience, wisdom. So take all those things into account when you're selecting a chief deputy auditor. It's not just about party affiliation. So, okay, now we're going to talk about a couple of cases where I find myself just genuinely empathizing with the auditors who were thrust into the middle of disputes that they really shouldn't have been in, and where they got stuck in hard situations and had really no good choices. The first case is Roberts versus the state on behalf of the Jackson County Board of Commissioners. Again, we're back to the Indiana Court of Appeals out of federal court land here. And this is a case where the auditor gets caught up in the middle of a dispute. So on March 3rd, 1971, the elected Jackson County surveyor dies. So this is something that counties have an enormous number of elected offices. From time to time, those offices are going to be rendered vacant, either through the death of the office holder or because somebody resigns or because somebody moves out of county for some reason. And so vacancies are going to occur. In this case, the surveyor died. And so we had a vacancy in the county surveyor's office. According to the Court of Appeals, after the vacancy occurred, the county commissioners, and the word that's used in the case is requested, which is a wonderful, weaselly, ambiguous word that the Court of Appeals uses. The county commissioners requested that the deputy surveyor, Howard Cummings, assume the office until they could get a successor appointed. So I am super curious what happened here. Did they meet? Did the commissioners meet and have a vote and make a motion to appoint Mr. Cummings, the deputy, as the interim surveyor? Did they pass a resolution? Did they pass an ordinance? What happened here? The fact that the Court of Appeals uses the word requested leads me to believe that this was pretty informal, and one of the commissioners maybe called him up and said, hey, keep the lights on, right? That's what it feels like to me. Now, I don't know that. That's not really the ideal process, but it feels like that may be what happened here. Okay, so Mr. Cummings did what he was asked to do, and he kept the surveyor's office open through March and April of 1971. He supervised the office, and then he submitted a claim for payment of his wages in March and April when he kept the office open. And in so doing, he certified his own claims. He promised that he worked all the hours he said he worked and that the auditor should just pay him because he promised that he did it. Nobody else looked it over. He swears, Scout's honor, I definitely worked these hours. I definitely need to get paid, right? Not the process that the State Board of Accounts likes to see. Don't do that. This is a really unique situation here that we're going to see from the Court of Appeals. So, all right. The county auditor got the payroll claim and said, whoa, this is irregular, and I'm going to get in trouble if I pay this, right? Which is, I think, quite reasonable for the county auditor to say, right? I should not be approving payroll for somebody who may not have lawfully even held the office, and second off, who's signing their own payroll voucher. So, and those are the arguments that the auditor makes to the court. The auditor says, look, I can't pay this. There are two reasons I can't pay it. Number one, upon the surveyor's death, the deputy auditor position was vacant, right? We have a bunch of cases, at this time at least, we had a bunch of cases saying that once the position is vacant, any appointments made by the elected official are void. And then the auditor said, look, and also this claim is not normal. I can't pay a claim like this. Again, the auditor, I think, is not doing anything untoward or not trying to harm Mr. Cummings. The auditor is in a situation where they're thinking, look, I'm going to get in trouble if I do this because this is not the normal process. All right, so the Court of Appeals sees this as raising two substantive legal questions. Number one, under the circumstances, could the auditor lawfully approve a self-certified claim and thus pay Mr. Cummings' wages? That's the way that the Court of Appeals talks about it, as a self-certified claim. And then upon the death of the elected county surveyor, was the deputy surveyor's employment considered terminated? So we have two very closely related questions, but very different questions. One is about claims, right? One's really about the auditor's power and when the auditor should or should not pay something. And the other one is about how we deal with vacancies in elected county offices. All right, so we'll take these one at a time. So with regard to the self-certified claim, what does the Court of Appeals say? And this one surprises me, right? They say, well, yeah, he can self-certify his payroll claim, which feels wrong, feels completely wrong. And in ruling that the claim is allowable and valid, the Court of Appeals uses some language that I really just can't track, right? The Court of Appeals says, the auditor contends that Mr. Cummings could not sign his own claim. Mr. Cummings was appointed to maintain the office and keep it open as directed by the county commissioners. Under this authority, Mr. Cummings had the right to sign his own voucher for his salary. Then the county commissioners could allow the claim for him as they had employed him and then direct and order the auditor to pay the claim in full. That's bizarre to me. That's very strange. When I read something like that where you have an explicit statutory process that wasn't followed and the court is just going to ignore it and say, well, it doesn't apply, my brain immediately wonders, what is the court doing here, right? They must have something else in the back of their mind, some sort of equitable or public policy concern that's motivating them to do something that's a little bit out in left field. So again, this is narrow, right? This is not the general rule, but in this narrow circumstance, we're going to see the Court of Appeals says Mr. Cummings ought to get paid. And I will say, too, thinking about this from Mr. Cummings' perspective, I do have some empathy for him. I mean, he didn't do anything wrong. Somebody said, please keep the office open, please keep the lights on. And he said, all right, I'll do that. And then when he was done doing that, working 2 months in the role of county surveyor, he said, hey, I'd like to be paid for those 2 months. So I do empathize with him as well on that side of it, but it is an unusual process. All right, with regard to the second question, was the deputy surveyor's employment considered terminated upon the death of the elected county surveyor? The Court of Appeals says no. And now this is really interesting to me. So I really find this to be a fascinating case, largely because I'm a total dork, but also because, you know, the result is not precisely what I would expect it to be. Usually when the Court of Appeals or the Supreme Court writes an opinion, they'll sort of have a formula for doing it. At the top of it, they'll talk about the facts just like we do. They'll say, here's what happened. Then they'll look at what their standard of review is, if it's for de novo, or if it's for clear error or something like that, to say how much they're allowed to stray from the opinions of the lower courts. Then they'll go through the procedural posture, what happened in the lower courts, what happened. And then finally, after you get through all that nonsense, the court will say, here's our analysis, here's our legal reading of what happened. And in that section, once they get to the legal analysis part of this case, the very first thing that the Court of Appeals does is it acknowledges all of these old cases that say when there's a vacancy, any appointments made pursuant to the now vacant office are invalid, they're void. And they say, we must agree that by the death of Edgar Lutz, by the death of the county surveyor, the term of his deputy terminated. So I read that sentence and I thought to myself, well, this is easy. He's not going to get paid and he was never properly appointed as the interim surveyor. But then the Court of Appeals bends over backwards and sort of does this excruciating, tortured analysis to find a way to say, actually, it was okay and he was allowed to be the surveyor. And so they go through these statutes, and at the end of it, we get this sort of gobbledygook sentence that says, considering the statutes, the Constitution, and the authority vested in the commissioners, and the further fact that Mr. Cummings was there at the request of the county commissioners, we have determined that he was legally employed and rightly operating the office. He was an employee of Jackson County, and as such employee, he was entitled to be paid a fair wage or salary for the work he did. So again, when I read something like this where it seems like you have a clear, if harsh, result, and the Court of Appeals decides to do something different than that, I'm wondering what's going on. And the Court of Appeals expresses its infinite frustration to the General Assembly in this case. And I love when courts do this stuff because it's sort of peeling back the curtain to explain what they're doing. And really what the court is frustrated with here is that the General Assembly has not taken action to create a more just result in this case. And they say, we must state that the problem of filling the vacancy of the county surveyor's office and the handling of the business in the interim of the vacancy is a problem which is necessarily to be borne by and taken care of by the General Assembly. This is a legislative matter, and this court abhors the court's legislating. So what the court is motivated by here is the fact that they have a void, or they see a void in state code, right? The General Assembly hasn't said, here's what you do when the office is vacant, here's who assumes the office, here's who gets paid. And so the court is stuck sort of doing a public policy thing and saying, look, we have to decide something that's just, even if it's not completely consistent with prior cases or with state code. And the court eventually says that's what's motivating them. So the real thing that's motivating the court here is the necessity of keeping all of your offices open at the county level. They don't want them shut down. I mean, can you imagine that? I think it actually makes a lot of sense. If the auditor's office, if somebody resigned as auditor and your office had to be closed for 2 months, the public could not come in and transact any business in the auditor's office. Can you imagine all of the things that wouldn't happen, all of the problems that would create for regular citizens in Indiana? It would be a disaster, right? So, and the court points this out. It says, look, if the recorder, and they use examples here, not the surveyor, but if the recorder of a county in Indiana might die, and if there was no one to keep the office open the following day or days in which it was closed, one of the days the office was closed might be the last day on which a lien could be filed, right? So it would create an unfair and unjust result for somebody. The same thing with the clerk's office. If somebody had to come in and file a legal action before the statute of limitations runs, but the clerk's office is closed for 2 months, that's going to create an unjust result. And so the Court of Appeals says all offices should be open on every business day as prescribed by law for the benefit of the general public and those needing to use the facilities of those offices. So that's what's really motivating the court here. They're saying, look, we've got to keep public offices open. That's the critical thing. We can't have the surveyor's office shut down for 2 months. That'd be crazy. So it's perfectly fine for the deputy to fill in. And at the same time, the court is screaming at the General Assembly to enact statutes that solve this problem. And guess what? The General Assembly actually listened in this case. So nowadays, this is not 1972 anymore, we have specific statutes that say what to do in the event of a vacancy in Title III. So the general rule is that when there's a vacancy in an elected office, the chief deputy employee of that office assumes the role in the interim until you can have a caucus and appropriately appoint somebody to fill that vacancy. And in the event that the chief deputy does not want to fill the role of auditor or surveyor in the interim, the county commissioners are empowered to appoint somebody who is eligible to serve in that role in the interim. So the legislature listened, right? This is a good story. At the end of the day, the Court of Appeals' extreme frustration with the General Assembly was answered by the General Assembly. All right. The last case we're going to talk about is in Allen County. Again, a much more recent case, a 1990 case. I guess I'm saying it's recent. That's 35 years ago now. I'm dating myself. But a 1990 case with the events that gave rise to the case from 1989. This is an Indiana Supreme Court case. So this is the highest authority we have in Indiana, the most precedential value. And when I read just the caption of this case, I can tell right away that something super dysfunctional is happening, right? This is Allen County versus Allen County, right? Allen County Council versus Allen County Circuit Court. That's never a good sign when you're suing yourself, always a bad sign, so not something you want to do generally. Okay, the basic facts here, and this is going to get into that space that I know everybody in county government loves, where we talk about the semi-independence of courts vis-a-vis county government. In September 1989, a judge in Allen County issued an order mandating increases in pay for certain court staff. So a judge said, look, county council, you are required to pay my people the amount that I say, and I'm issuing an order directing you to pay that amount. Well, the Allen County Council was not super stoked about that idea, and they said, nope, we're not going to appropriate those funds. We're not paying those salaries in the amounts mandated. Good luck. Sorry about that. That's a very nice order, Judge, but we're not going to do it. Well, the judge had sort of a backup plan, and the judge said, well, that's okay. If the county council won't listen, the order then says that the county auditor, even if the county council won't appropriate funds, has to make these payments. Oh my goodness. Like, I read that and I am like, oh my God, the poor county auditor. Can you believe this sticky situation that the Allen County auditor was in here? If the county auditor pays the salaries, they're clearly violating statute because they can't pay money that's not been appropriated by the county council. But if they don't pay the salaries, they're clearly violating the judge's mandated order, and so they're not compliant with a court order. So they could get in trouble if they do. They could get in trouble if they don't make the payments. So the judge and the county council are having a dispute, and the auditor gets stuck in the middle, where everybody is telling the auditor what to do, and they're telling the auditor opposite things. I hope this never happens to any of you. That sounds just miserable to me. I hope that I'm not seeing nods indicating that you've been in this situation. I hope that's not what that means. But anyways. Okay, so I was really curious because when we hear these sorts of statements about the judge is ordering us to pay a certain amount and we have no control over it, the fear, I think, from local units is always that judges are going to order exorbitant salaries for their people, right? For the folks that are under their jurisdiction whom they get to set the salaries for. And so, one of the things the Supreme Court spent an enormous amount of time doing in this case is talking about the reasonableness of the mandated salaries. Now, I'm old enough to have been alive in 1990. Even I think by 1990 standards, these are not crazy high salaries for this type of positions, right? The mandate said that the chief public defender's salary in Allen County was going to go from about $22,000 to $30,000. That the assistant public defender, these are attorneys, would go from $15,000 to about $22,000. And then it said they're going to mandate a new public defender secretary's salary at $12,000, about $12,000 or $13,000, and probation officer's salaries at a minimum of $20,000. So in my mind, when we look at these numbers, and the Supreme Court spends a lot of time talking about the numbers and how they're sort of well within the normal range for these positions, and even at the low end of that range, we're not talking about sort of Cadillac level salaries here. Okay. Well, the Supreme Court at least pauses for a moment in its decision to appreciate that it's dealing with competing interests. So it points out that the appellant county councilmen have the unenviable responsibility of distributing available funds among the various branches of county government. And you can tell in the case that the county council has made this argument over and over again. They say, look, this may not seem like a lot of money. It may not seem like exorbitant salaries, but we don't have a huge number of resources at our disposal, and we are not prioritizing increasing pay for these positions at this time. That's sort of the county council's position. This isn't a crazy position. But then the court sort of hedges and goes back and says, at the same time, the trial judge has the responsibility of supervising the functioning of the circuit court, and that it is essential to the function of the circuit court that competent personnel be employed, and that you can't hire competent personnel unless you have salaries that are comparable to salaries paid to persons of corresponding ability in the community. So the court is acknowledging both sides of the difficulty here that Allen County is faced with. Well, the council was not happy with the judge's order, so they sued the judge, and they made two basic arguments. First, they said, hey, auditor who's caught in the middle, you're not allowed to legally pay claims unless we appropriate sums for you to pay. We don't care if there's a court order. Do not make this payment, county auditor, because we haven't given you the authority to make that payment. And then the council further argues that the circuit court cannot issue an order like this, right? You can't order payments without the council appropriating funds. So the council is seeking sort of an opinion with regard to two persons, both the auditor and the judge in this case. I think we all know that the council is going to lose in this case, right? But these aren't crazy arguments. I mean, they're pretty reasonable arguments, but they're not going to win the day. Okay, so the legal questions that come out. Can the circuit court mandate that the county council appropriate particular sums for the payment of salaries to certain court personnel? We've already sort of talked about this. That's really about the court's power versus the county council's power. And then the second question is, if the council refuses to appropriate money in accordance with the court's order, can the auditor pay salaries without an appropriation? Is that sentence in the court order that says, auditor, I don't care what the county council does, I don't care if they appropriate money, you will pay these people, is that a valid sentence? Okay, nothing shocking here. So can the circuit court mandate that the county council appropriate particular sums for the salaries of certain court personnel? Yes, definitely. It's never surprising or shocking to me when a court says that courts have power. That's maybe the most reliable sort of outcome you can count on. If there's a question in a legal case about whether a court has the authority to do something, I'll bet you dollars to donuts that the court says that they can do it. So it's not surprising that the Supreme Court says, hey, the circuit courts have independent power. And the Supreme Court says it in this wonderful way, right? They say it like, oh yeah, we settled this long ago, right? This is not a big deal. Everybody knows this. The power of courts to mandate funds for their operation has been clearly established for many years. The county council has no choice other than to comply with the mandate. Their action in doing so is ministerial, right? If the council does not comply with the mandate, they are subject to judicial sanction. So, I mean, that's really a strong statement from the Supreme Court. They're telling the county council, look, you are nothing more than, and this is great, this is like when we used the word amanuensis earlier, right? You have no power here. Your role is to do what you were told to do. You have to do it. You have no authority. You have no decision making. You have no choice. You will just do what you're told to do, county council. And then he goes on to say, look, you're going to be subject to sanction if you don't do it. You will appropriate those funds or we're going to sanction you. And that means we're going to haul you in independently, council members, and we're going to fine you. And if the fine doesn't work, then we're going to put you in jail. And we're going to do that until you pass an ordinance that says this is the amount that's appropriated to pay court salaries. So the Supreme Court is not screwing around here. They are using their biggest gun to influence the county council to do what they want them to do. So, and then with regard to the auditor, if the council refuses to appropriate money in accordance with the court's order, can the auditor pay salaries without an appropriation? I bet you can guess what the Supreme Court said. They said yes, definitely. The county auditor serves only as clerk of the county council in paying out county funds. The auditor's action in response to the court order is not contrary to statute, but rather is a performance of her duty to dispense county funds. So it's the same type of language, right? Your role, county auditor, when you have an order and mandate directing you to take an action is really limited. It's very modest. Do what the order says. Don't think, just do what the order says. So, what do we get from that? When you're faced with competing interests like this, follow the court order, right? That's what the court's saying. And sort of the takeaways here, and there are a few. Courts have broad power to set the salaries of staff under their jurisdiction. If you didn't know that already, that's one of those things that leads to an enormous number of questions that Stacy and Ricky and I answer, because it's such an interesting and unusual legal relationship between counties and court officials. And so courts have broad authority here. Comply with court orders. Again, I don't know. That's really simple. But when if you're caught in the middle of a dispute like this, the court order is going to give you a safe harbor, right? That's going to be something where you can say, look, I was going to be subject to sanction. I was going to get in serious trouble if I disagreed with what a judge told me to do. So if you're stuck in the middle of a dispute like this, the court order is going to be the safe side of it most of the time. And then, of course, I wouldn't be me if I didn't also suggest avoid disputes like this if you can. One really fascinating sort of coda to this particular case that I think is interesting, and it shows up in the Indiana Supreme Court order in this case, is that Allen County ended up having to foot the entire legal fees for this case on both sides, right? So the county council went into this case saying, look, we don't have a lot of money. And I think they were being very genuine with that. They were saying, it's not that we don't want to pay court staff more. It's not that we don't agree that if you did a salary study, you wouldn't find that our court staff are underpaid. It's just that we don't have a lot of dollars at our disposal, and we have to make brutal, hard decisions about which people in the auditor's office or the surveyor's office or the highway department are going to get raises. And we prioritized different folks to get raises than court staff, and we don't have a lot of extra money. That was the council's argument, and it was, again, we're not in crazy town with that argument. It's a reasonable argument, and the court, of course, totally rejected it. But at the end of the day, the county council not only was ordered to pay more to the folks that are under the court's jurisdiction, but they were also directed to pay the legal fees for both parties. And I don't know how many times you guys have seen invoices for legal cases that go all the way up to the Indiana Supreme Court, but I promise just paying one side of the parties' litigation, of the parties in the litigation of their legal fees is not a small sum when you get all the way to the Indiana Supreme Court. And here the county council had to find money, despite having very limited resources, to pay both sides. And so the cautionary tale is that disputes are expensive. If you're going to fight with yourself, it's particularly expensive. And that's really a difficult thing to take into account when you think you might have the authority to do something. But if you can resolve things at the local level without going all the way up to the Supreme Court, without going to court in the first place, that's always going to be a better result locally and in terms of protecting local resources. So, all right. Well, that is the last case. I think we have a couple minutes. I don't know if people have questions or thoughts or anything. Hold on one second. I think Stacy's going to bring you the mic so everybody can hear.
I'm coming.
I'll do my best to answer, by the way. I don't have all the answers with regard to these.
I know you don't have all the answers. I'm not an auditor. My wife is the auditor, but I'm the county coroner. And when you spoke of the surveyor dying, and if it's an elected official, if it's in the realm of the constitutional offices, we had this happen in our neighboring county, in Stark County. They had no chief deputy for their coroner, and he resigned at 12:01 midnight. And the judge called me and asked me if I would come across and be their coroner as an appointed from the judge, because he said that the county couldn't open and function without the constitutional office being filled. So if you ever have that in your county, please make sure that you fill that constitutional office before you get the courthouse opened. Now, that day in Stark County, it didn't happen until about 10:30 because again, you spoke of Republicans, Democrat Party. The judge was of one party and I was of another party, and I came over there and he wanted to make sure that this was in the newspaper so that there wasn't any complaints. So just bear in mind, if it's a constitutional office that you lose, the county is not a county until that constitutional office is fulfilled.
Yeah, I think that's a really good point. And that's really what the court is motivated by in the Roberts case, right? I mean, this is, they go through this excruciating legal exercise of finding a way to say that Mr. Cummings, the chief deputy, should get paid and that he was lawfully appointed, right? Because what they're terrified of is that counties are going to say our hands are tied and this office is going to be closed for weeks on end. They are terrified of that result, and they want offices to be open and functioning. So I think that's exactly right. That's what's motivating the court in the Roberts case. That's right. So, anybody else?
My question's about payroll approvals. By law, the department head is supposed to be signing off on those payroll approvals, payroll claims. Can the first deputy or chief deputy also have the authority to do that?
I'm going to defer to Stacy and Ricky on that one, whether or not that's something we would take audit exception to.
Okay, and then further then, if it's not an elected official's office, if it's a department head, can the assistant department head serve in that same role then as a first deputy would and sign off on a payroll? And for council and commissioners in a county that's not so big, their secretary signs off, but that includes her own payroll. Is that allowable, or should the auditor be signing off on?
Yes.
Awesome, thank you.
I'm pretty sure I know the answer, but I'm going to let Ricky say the answer on these things as well. So
No.
I love it. Yeah.
Okay, so you can have a deputy sign off on time cards, okay? They can be, you can say, hey, we've got all these people in our office. I'm going to give Mike, my deputy, the authority to sign over all these people's time cards. He, however, cannot sign his own. Okay, you can never sign your own time card, right? You can't say, yeah, of course I worked it, right? There's no control there. It has to be somebody else, okay? In the commissioner's stance, yes, they can delegate that to their administrative assistant or whatever. But again, she can't sign her own, okay? So it just depends. It just needs to be somebody knowledgeable of those hours. Okay, so it can't be like, we're gonna designate the highway to do the health department, right? Like highway has no knowledge of what health department is working. Does that make sense? Did I answer it all?
That's great.
You just won't be on the recording. Sorry, she's right there.
When you say the time card, are you talking time sheet or the payroll voucher?
Okay, so those are two different things.
Okay, as far as the payroll voucher,
Okay, so the timesheet is when you're signing off on that is just saying, yes, that person worked those hours. The voucher is what comes to you and has to be, and we're going to talk about this a little bit more tomorrow
Oh,
too.
okay.
But the payroll voucher will come to the auditor's office. That's what you have to audit in order to be paid. All right, that needs to be by whoever. I mean, it could be the department head, but again, the department head might be on vacation. Right? So their deputy or whoever's next in line can sign that, right? You don't want people to not get paid because I took a vacation, right? It just needs to be somebody in line in that department. And it would be that department's decision to make,
who signs it?
okay? Because it shouldn't be the auditor saying, well, health department, it has to be that person. Do you know what I mean? Because that person may have no idea.
Yeah, we have quite a few departments, like our fairgrounds, our veterans, and stuff that we thought our commissioner should be signing, but like the actual voucher itself, but then they weren't sure either if they should be doing that.
I mean, I would leave that up to you guys as a decision to make who's the most knowledgeable person to be signing that. So if you only had one person in the veterans office and commissioners wanted to take that over, that seems perfectly reasonable for them to take over that part. Okay. You did a wonderful job. That's great. All right.
Yes, thank you.
So I have a unique question.
A unique question. Okay, I
Yes.
love unique questions.
So I know the judges have mandate powers. However, my prosecutor also says he has these same mandate powers as a judge. And he has a letter of opinion from Todd Wakita's office. And so he has never issued a mandate yet. But he informs us that he has that same power.
Yeah, I think he probably does. Bad news, sorry about that, but prosecutors' offices are considered independent offices. I would always want to understand specifically what the prosecutor was doing in a particular case. I feel always a little bit uncomfortable giving super generalized advice, but the general rule is that prosecutors are going to fall into that same bucket as court staff, and they're going to have the authority to set salaries for their folks. So, yeah, and Ricky informs me that she's going to talk about that tomorrow, actually. So you're going to get more on that subject.
You guys just love payroll, don't you? We love payroll questions. Good, thank you.
I'll try to condense this and keep it as short as possible. Last year, we had a company, which actually every year they're late, turning in their abatement paperwork.
Can you say that one more time? I'm so sorry.
We had a company turn in their abatement late. The council for the town tabled it multiple times, and I've already talked to State Board about this last year, but they didn't sign it until late in August, okay? I already had everything certified, everybody did. Then they turned around and the company hired an attorney who prepared a resolution waiving noncompliance with the filing deadlines for the compliance of the statement of benefits, the CF1. They didn't sign that or do that until, I'm scrolling because I'm looking at it, May 13th, 2025, which is after they paid their spring installment. Now we're being sued because of this to give them back their $83 million abatement. I think I'm screwed, personally. How can they file this well after the fact?
Yeah, that is a super intense question. I'm probably not going to be able to provide you great guidance on, and I'm sorry about that. Usually, again, I will say this, you need to talk to your own attorney. It sounds like you're already involved in a legal dispute. Clearly, you're involved in a legal dispute about this, and a really intense one with a huge dollar sum on the table. So that's a big deal. Usually you cannot locally decide that you are going to waive a deadline. Not always, there are exceptions, but usually if something is in code that it has to be done by a certain time, it has to be done by a certain time, and that's a firm deadline. That's as much as I can say about that. Whether or not there's a specific exception, the specific facts that gave rise to this circumstance, I can't really speak to, but hopefully you're engaging with your local council and they're working hard on trying to figure out how this is supposed to go. So.
Actually, the county's the one who's ended up having to fix this, not the town, because the town's the one that approved the abatement.
I see.
They're skating.
Yeah. So
Their
it's county.
attorney, to muddy the waters, their attorney is also our county attorney.
Oh, goodness.
Which, anyway, we ended up having to hire a different attorney who was costing me an arm and a leg, and the town is getting off scot-free, basically, because they're not doing anything. They didn't even prepare this resolution. The attorney for the company did, presented it to the town's council and said, you need to sign this. And they did.
So I think you're saying the abatement is related to the town's actions on behalf of the company, but now the county is stuck being one of the parties in the suit along with the company, even though the town initially granted the abatement causing the problem. They don't even have to worry about the litigation or the legal fees associated with it. Yeah, the world is totally unfair sometimes, and that
And
stinks.
it's cross-county, which really sucks.
Yeah.
Anyway.
I think we're just about at time, so if you have any other questions for me, I'll be out at the table for a couple more hours. Ricky and Stacy and Vicky will be here for the next day and a half as well, if you have questions for them. And if you have questions for me and I'm not here,